All right, so what did the federal rules do to try to pick up on this electronic discovery nightmare? Well, what it did is it enacted a number of changes. They're small changes, and they start in Rule 26. Rule 26A1B requires that there be some automatic exchange and disclosure of information. And what is that material that needs to be disclosed? The material that must be disclosed at the outset of the litigation without waiting for a discovery request includes a copy of or a description of by category and location of electronically stored information. So obviously, what you need to do is you've got to have an interview very early on with your IT person in the company of the client, and you've got to find out what is it that you've got, how is it stored, and I need to be able to provide that description to the other side, and that's going to be something that's going to just voluntarily be turned over as part of 26A1B. What else do they provide? Well, they provide the not reasonably accessible rule. Under Federal Rule of Civil Procedure 26B2, a party need not provide discovery of electronically stored information from sources that the party identifies as not reasonably accessible because of undue burden and cost. Now let me just pause there for just a second and make this mention. Remember what we saw in Zuba Lake and what we saw in the Morgan Stanley case is that in both of those cases there were business reasons for people to have data and to have it stored. They are business reasons that are there, whether it's for disaster relief plans or for shutdowns, electronic shutdowns at times that occur during a company. And so the fact that there are already good business reasons for electronic data to be preserved and to be maintained exists in most companies today. And recognizing that, then you need to ask yourself, well, how much more of a burden is it going to be able to capture this information in accessible form, in form that would allow us to be able to get at it and to search it and to make it usable? That is where the cost is really going to be. So, the Rule 26B provides that you don't have to turn over discovery that's not reasonably accessible. If the opposing party files a motion to compel or for protective order, the burden is on the responding party to show that the material is not reasonably accessible. Even if the showing is made, the court may nonetheless order the discovery if the requesting party shows good cause. The court may also specify conditions when ordering this discovery. So that's Rule 26B2B. Now, what do we do with the question of privilege? If what we've got is we've got this enormous amount of data, as you heard in the Morgan Stanley case, the numbers, 695,000 emails, what do we do with the task of preserving privilege? Of course, what we've got is we've got to do the best job we can before it all gets turned over to the other side. We've got to do the best job we can of being able to protect that and to name it and to tag it and to preserve it and to then keep it confidential. But the rules understand that within this massive electronic information, privilege can slip by. And so what we have is we have a very specific provision in Rule 26B5B that provides a clawback of privileged material. Under Rule 26B5B, a party that inadvertently produces privileged or trial preparation materials can notify the other side of its claim of inadvertent production and the basis for such the claim. After being notified, the other party must return, sequester, or destroy the specified information and cannot use the information until the claim is resolved. So what we see is, we do see that there is some leeway that's cut. Obviously, still the job of the lawyer on the front end is to make sure that it's not turned over in the first instance. But if in fact they haven't done what's reasonable to try to protect the privilege, if they have turned it over after having done what's reasonable to protect the privilege, then there's a clawback provision that's provided by the rules. Note also there is a safe harbor rule under Rule 37F of the Federal Rules of Civil Procedure. The court may not, absent exceptional circumstances, impose sanctions under the rules on a party for failing to provide electronically stored information lost as a result of the routine, good faith operation of an electronic information system. And I want to talk and return more to that as we go through this course, but Rule 37F provides a safe harbor. And then finally, what we have are an information exchange set of rules that are provided in Rule 26F. The information exchange provides that the parties should meet and confer now about preservation and production of e-discovery. This is a crucial part of the rule for you to be able to figure out how to deal with. If what you think of this as these steps of litigation hold, and now what I'm going to do is move off from a broad litigation hold into an area where I'm going to start to negotiate the production process, what I can do is I can meet and confer, and it's at this point where I can negotiate the reasonably targeted discovery exchange of information that presumably will keep the parties trying the case on the merits as opposed to trying the case on costs of discovery. Let me also say to you that there's a Form 35 which requires the description of the parties' proposals for handling e-discovery. And under that Form 35, it lays out a method, a joint protective order type of a document that will allow you to go ahead and protect and preserve, but still get at the information that each side has on this case. Let me also say that the Rule 16 conference provisions also anticipate a pretrial conference at some point where what you have is a scheduling order where the e-discovery materials can be hashed out with the court's input if that's something that you also want to solicit. The scheduling order can provide provisions for electronic discovery or agreements that the parties have reached about that. And that, folks, those are the new rules. The requirements are quite general. One of the purposes in this program is to explore how to meet these requirements in a practical situation, in a pending case. And we're going to do that with a hands-on exercise next that pose real-life problems in getting through the e-discovery successfully.